representing the petitioners and Team Code 17 is representing the respondents. Thank you.
It's a new link. This is the main link. Wait, check it. Ma'am, I'll send you a new link. Send it to the IT team. Check it first.
Why new link? This will not work.
Okay. Send me a new link again. Yeah, it's working.
It says live stream offline.
That's fine. I'll send a new link. Send it, please. Ma'am, this is the last one.
I think you should announce it on the mic to put everybody's phone on silent. They already did. It's starting now. If you want, you can come, or you can sit at home and watch it online, live also. YouTube. I'm sending it. ठीक है. हाँ.
Your Excellencies, before I begin, I just want to make a quick check if I'm properly audible. Your Excellency, if I am properly audible to everyone in the bench. Slight interference.
She's here.
Your Excellency, is it better now? Shall we proceed? President of the Court, Your Excellencies, may it please this Honorable Court. My name is Abhinav Dixit, and I am the Agent 1 on behalf of the claimants in the present matter. Today I, along with my co-agent, Mr. Agarwal, and of counsel, Ms. Tiwari, shall be representing the interests of the state of Nagaland before this Honorable Court. Your Excellencies, of the 1 hour that has been so allocated to us so graciously by this court, we shall take first 30 minutes to address this court with respect to issues 1 to 4, those comprising the questions of jurisdiction, the self-defense, the attribution of the responsibilities of the terrorist attacks to the state of Nagaland, and finally, the responsibility owed by the state towards the technological innovation. Subsequently, my co-agent shall be taking 25 minutes to address this court with respect to issues 5 and 6, those concerning the questions regarding genocide and reparations that are owed to the country of Mahindra. Your Excellencies, we humbly reserve 5 minutes for the rebuttals. Your Excellencies, this is a classic case of a bigger country dictating its terms to a smaller country, by hook or by crook. Your Excellencies, the present case is a case where there is a terrorist attack that has happened on the respondent state, and we humbly agree to that. However, Your Excellencies, that terrorist attack, its nature, and whatever transpired with mainland, the biggest contentions that will be present now would be simple: that there was no attribution towards the claimant state, and further, even if by some extension such an attribution is to be proved, the acts were not proportional. Your Excellencies, the state of Mamaland comes before this court begging for the rights of its citizens that are left without food, without water, and without any communication. Your Excellencies, 10,000 of our citizens have been killed. Out of a 10 million population, that constitutes a large chunk. Today, we requestfully submit before this court to set the course of law right and send out a message to big and developed states like England that the international law and its order still protects smaller states like this. If Your Excellencies have no preliminary inquiries, the agent seeks the permission to move to issue notice. Much obliged, Your Excellencies. Your Excellencies, with respect to issue 1, the primary question before this court is whether the parties today before this court have come to this court, and whether the court has jurisdiction over the issues that are being presented. Your Excellencies, to firstly answer, Your Excellencies, perusing the written submissions of the respondents, the arguments that they have raised is firstly that there were no negotiations that were made before approaching this court. Secondly, that the claims against Mr. Yoda formed a part of domestic legal system. Third, that the International Criminal Court is a better suited tribunal for the present matter. And lastly, that the process of law has been abused by the applicant state by raising unsubstantiated claims before this court. Your Excellencies, firstly, to provide a general overview of the requirements that would suffice for the jurisdiction of this court. And I will divide the submission into 2 parts. Firstly, Your Excellency, with respect to the stature of the parties before this court, Article 34 of the ICJ statute provides that only state parties may be a party before this court. Your Excellencies, it is beyond any doubt that both Mamaland and Mainland are state parties, and therefore this court has jurisdiction. Subsequently, with respect to the subject matter jurisdiction, Your Excellency, the claim before this present court has been brought under 2 treaties. Firstly, the UN Charter. The UN Charter, Your Excellency, Article 36 of the ICJ statute clearly provides. Article 36 of the ICJ statute provides that any question regarding the UN Charter may be brought and before the International Court of Justice, and indeed the International Court of Justice has a compulsory jurisdiction in such matters. Your Excellency, the primary issue that the state of Mamaland raises is the violation of Article 2, Clause 4 of the UN Charter, which provides for the principle of non-aggression. Your Excellencies, from a bare perusal of facts, and more specifically, Your Excellencies, paragraph 8 of the Moot proposition, it is clearly visible that mainland in retaliation went to war against Mamaland, a state which was not even prepared for such a war. Your Excellencies, the further your Excellencies, the further ground on before which we appear before this court is Article 9 of the Genocide Convention, which also provides for a compulsory jurisdiction of this court. Now, Your Excellencies, since the subject matter and parties' jurisdiction has been satisfied, I shall address the contentions that have been raised by the respondent state in the present matter. Your Excellencies,
decide the jurisdiction based on their conclusion. We are supposed to decide on jurisdiction based on your cause of action before the ICJ. They may raise many contentions. How do you justify in approaching ICJ based on the cause of action now we have?
Indeed. Your Excellencies, a cause of action arises from an attack, an armed attack by the AI operated weapons of mass destruction that have been deployed in our territory. Your Excellencies, as is clearly provided from the statement of agreed facts, this caused death and destruction of around lives of 10,000 people, including the most vulnerable groups such as women, children, and the elderly. Further, Your Excellencies, in such an armed conflict, even the law regarding armed conflict was not followed by the state of mainland because no humanitarian aid was allowed to enter into the country of Mamaland. Your Excellencies, a combined effect of the war, the satellite blockage, and the humanitarian aid being stopped has resulted in a scenario where the complete population, as presented in paragraph 10 of the Moot proposition, of the state of Mamaland is left without any food, without any water, and without any communication, which constitute basic necessities. Further, Your Excellencies, this is the cause of action that we bring before this court and humbly request this court to admit this dispute and apply its jurisdiction. If Your Excellencies have no further questions with respect to jurisdiction, I humbly request your permission to move to further issues. Much obliged, Your Excellencies. Your Excellencies, with respect to issue 2, and I would read it out for the benefit of this court. It says, is the state responsible for the terrorist attacks, including cyber warfare on another state, when the terrorist organization is known internationally and is banned from the country? Your Excellency, in the present case, this refers to the attacks made by the freedom warriors on the state of mainland. My apologies, Your Excellency. Your Excellencies, now there has been an attack that has been conducted by the state of mainland upon Mamaland, and they claim within their written submissions that such an attack is done in pursuance of Article 51 of the UN Charter, which provides for an inherent right of self-defense. Further, Your Excellency, to proceed against the state of Mamaland, even when such attacks, as agreed by the respondent states, is conducted by freedom warriors, they have used the Chapter 2 of the draft articles on the responsibility of states for internationally wrongful acts by contending that the internationally wrongful actions of the freedom warriors are attributable to the state of Mamaland. Your Excellencies, we'll humbly try to refute both of these contentions. But most importantly, Your Excellency, the crux of the argument, and indeed the crux of the complete submissions before this court that the state of mainland, the applicants, shall be undertaking in the present regard, is the fact of attribution. Your Excellencies, we empathize with the respondent state in the fact that there were indeed attacks carried out on their communication satellites, that indeed there was probably, and we are not sure because the facts do not provide us a complete understanding, but maybe there was a deepfake video that was in circulation. However, Your Excellency, what we primarily contest here is the lack of any peaceful resolution opted by the respondent state. Your Excellencies, in the completely perusing the whole fact sheet, there is nothing to point or indicate that Freedom Warriors as a terrorist organization was based in out of the state of Mamaland. There's nothing in the proposition, Your Excellency, which supports this. On the other hand, Your Excellency, if you may refer to paragraph 6, Your Excellency, if you may refer to paragraph 7 of the Moot proposition, it clearly mentions that as tensions escalated, a terrorist organization banned by the state of Mamaland, and this is very important for the perusal of this court, Your Excellency. The terrorist organization was banned by the state of Mamaland, and yet, there's nothing else in the proposition to show that if this was based out of the country or if there was any sort of state support being provided. Now, Your Excellency, with respect to Article 8 of the RCEBA, for an attribution to be made to a state in the present context, the most important components are a direct control over the actions of such violated states to be shown. Your Excellency, the threshold for this was set in the Nicaragua case, wherein the court, even though this court may rely upon the fact that the ruling was indeed against the USA in that instant case, however, the court in that instant case differentiated between the quantum of liability based on the amount of participation that the US could exhibit in that case. Your Excellency, there are two tests that have been prescribed within the international jurisprudence to determine the control. The first is the effective control test, the second is the overall control test. And Your Excellency, in the case of DRC versus Uganda, the International Court of Justice has explicitly read down the standard of effect of overall control that was set forth by the Permanent Court of Arbitration, saying that a test such as an overall control test expands beyond a reasonable point the liability of a state and the attribution that can be made to it. Your Excellencies, why does this point of contention arises? This arises from the breach of Article 2 Clause 4, which provides for a principle of non-aggression. Your Excellencies, Article 51 of the United Nations Charter provides for the right of self-defense, and through recent legal developments, through the state practice, and through the opinions of the academia, the position of the law has changed from self-defense being exercisable only towards state actors to now non-state actors as well. This is a condition that the respondent state will make, and we agree to it, that there has been an evolution in international law. However, Your Excellency, as was noted in the resolution 1397 part 28 adopted on 28 September 2001, immediately in the aftermath of the 9/11 attacks, it was said that when such non-state actors engage in acts that violate the rights of the citizens or the state, and they indeed constitute an act of aggression, there is a right of self-defense available. However, that right is restricted to be exercised only against the non-state actor. Your Excellency, the most glaring example of this was that post the 9/11 attacks, the US started taking a more proactive role within the international sphere, and in 2011, in Abbottabad, there was a raid carried out by the Navy SEALs of the USA, in which Osama bin Laden was killed. However, Your Excellency, the differentiating factor between that case and this case is that even though there were allegations upon Pakistan that it was terror financing the activities of Al Qaeda, there was no action taken against the state of Pakistan. Maybe the court may argue that there were indeed some countermeasures that were taken against the state of Pakistan, but there was no action taken under the garb of self-defense, because self-defense, Your Excellency, provides a particularly high threshold whereby international peace may be breached. For this reason, Your Excellency, that case and the general development whereby state actors are allowed to claim self-defense right against non-state actors must be differentiated from the present case. What happens in the present case, Your Excellency? In the present case, we go to paragraph 7, where it's clearly shown that the applicant state, which, Your Excellency, is a developing state with limited resources and infrastructure, has already banned this terrorist organization. Your Excellency, the facts are silent on the fact if and whether there was any past activity of of this terrorist organization within the state of Mamaland. It is also silent on the fact of where from this freedom warriors organization originated. In which case, Your Excellency, the fact that they have banned them as a terrorist group may very well be because of international obligations. For instance, Your Excellency, the United Nations Security Council issues a list, and there's a list of internationally acclaimed terrorists. And these internationally acclaimed terrorists and terrorist groups are banned within each member state of the United Nations parties of the United Nations, unless some states may take an explicit objection to it. Your Excellencies, with this in mind, now there is nothing to exhibit that the actions which were taken by freedom warriors were either taken from A, the territory of Mamaland, B, was financed by Mamaland, or C, was provided some technical expertise by the state of Mamaland. In this case, Your Excellency, there are no facts to attribute these actions to the state of Mamaland. Now, Your Excellencies, even if, with respect to issue 2, we humbly submit that therefore there should be no state responsibility upon the state of Mamaland for the terrorist actions that were carried out by the freedom warriors.
Actual context is developed through customary international law or any other convention or
Your Excellency, it has primarily developed only through customary international law. However, in 2001, the ILC undertook a codification exercise, and these articles regarding state responsibility have been codified within the draft articles on responsibility of states for internationally wrongful acts, or the RCEWA as it is colloquially called. With respect to what is the concept of indeed. Your Excellency, for that, if I may ask you to peruse, just a second, Your Excellency. Page 27 of the applicant compendium, Your Excellencies, wherein the ILC draft articles have been provided, and I may read it for the. Your Excellencies, Article 3 of the RCEWA deals with the characterization of an internationally wrongful act, and it says, I quote, the characterization of an act of a state as internationally wrongful is governed by international law. Such characterization is not affected by the characterization of the same act as lawful by internal law. Your Excellencies, in the present case, to further understand this, the principle of non-aggression, which is part of both the United Nations Charter and as well as the customary international law, its violation would constitute an internationally wrongful act within the meaning of RCEWA. On the other hand, we humbly submit that the actions of freedom warriors, which would amount to the acts of aggression, however, since they are not attributable to the state of Mamaland, would not give rise to the state responsibility of the state of Mamaland. If Your Excellencies are satisfied with the arguments with respect to issue 2, the agents seeks permission to move to issue 3. Much obliged, Your Excellencies. Your Excellencies, with respect to issue 3, the question is, does the act of mainland amount to self-defense, or is it considered a use of force? If self-defense, is it proportionate or in violation of the principle of sovereignty? Your Excellencies, the basics from which the question originates, as have been already discussed, is whether if it is a use of force or whether it is a self-defense. Ordinarily, Your Excellency, this would qualify as an from the respondent state. This would qualify as an act of aggression because of the Article 2.4, which clearly prohibits that a state party may not use force against another state party. The respondent state, in their written submissions, have intended to use Article 51 of the UN Charter as a defense to this. Your Excellencies, we humbly disagree with the use of this article for the reason that we have already submitted in issue above, that is, that the actions are not attributable to the state, which means that the defense against aggression will also not incur towards the state. So with that, the question therefore is that even if we consider it to be an exercise of self-defense, is it proportionate or is it in violation of sovereignty? Your Excellencies, to answer this, we refer to the 3 criteria that have been envisaged for judging whether an action is indeed necessary, and these 3 criteria are the criteria of necessity, imminence, and proportionality. Now, Your Excellencies, in examining the present facts on each of these criteria, firstly, the criteria of necessity. Your Excellencies, the criteria of necessity exists to ensure that in case there is a violation that is being committed against a state has the inherent power to immediately respond to it when it has no other alternative remedy, so that the violation that is already being committed does not go on increasing in quantum. In the present case, Your Excellency, as can be perused from the paragraph 7 of the Moot proposition, the harm that has occurred to the state of mainland is that some of their communication satellites were infected with, there was a cyber attack that was carried out upon these satellites. Your Excellencies, it's important to understand the technology in here to apprise and appreciate what exactly transpired. Your Excellencies, these satellites that are under question are launched by Galactics, which is a company based out of Moonland. Moonland is a third party within this dispute. However, it is not a party before this court. Now, Your Excellency, the way these satellites operate is that the physical embodiment of a satellite is sent into space, and the attack that has occurred on the computer systems that manage the satellite. Now, Excellencies, we agree that in modern times, such attacks on these such satellites, which indeed serve important state purposes, may amount to an act of aggression. However, Your Excellency, it's as easy to deal with such attacks as it is the cyber attack was initially. The only thing, Your Excellency, that is supposed to be done in such a case is this computers or these softwares that are managing these satellites, which are affected, can merely be reset, or merely these viruses could be removed from the software, since there is no harm to the physical embodiment of the satellite that is present within the outer space. Your Excellencies, this is a simple remedy that existed in the present case. The other violation that the state of Mainland alleges upon Mama Land is that this Mr. Yoga, who was a high-ranking government official of the ruling party, there is a deep fake doctored video of his that the freedom warriors again have published allegedly within the cases. Indeed, Your Excellencies, I am not able to clearly hear you.
You said about the attack on the satellite. Is it not an attack on the satellite? Is it an attack on the satellite, or is it an attack on the computer system that operates satellite?
Your Excellencies, as we can peruse from paragraph 7, line 3 of the proposition, it clearly mentions that there was a cyber attack. It wasn't a physical embodiment of an attack so as to disrupt the physical embodiment of a satellite. There was an attack on the system, cyber computers, systems that manage it, whereby, let's say, the satellites were probably hacked. However, Your Excellencies, the way these hacking attempts have been dealt by the international community and in general states is by disconnecting these computers from the internet so that hackers stop getting access to such systems and then working with the software.
How we classify this attack? What kind of law that would operate in such situation?
Your Excellencies, in case of the cyber attack?
And we are asking because according to you, it's indirectly that affected operation of the satellite.
Your Excellencies, could you please?
No, you said it is that in fact is affected the operation of the satellite, right?
Indeed.
So how do you classify this kind of attack? Of course, you said it's cyber attack. Then which law would apply in such situation?
Your Excellencies, specifically with respect to public international law, in such within the Talon manual, it has been held that cyber attacks that threaten the sovereignty of a country may be classified as an act of aggression within the meaning of the UN Charter.
The Talon is only a manual for guidelines. That itself says that it is not a kind of a part of international law. It's only collective of different manuals.
Your Excellencies, in that case,
is it not internal law or external? I mean, any other public, international public law? How in what extent?
Your Excellencies, even the laws and treaties that exist with respect to satellites and outer space objects, they generally deal with the waste satellite, with the outer space waste, with the physical embodiment of satellites that are sent within the space.
But outer space does not speak about cyber attacks.
Indeed, Your Excellency, which is why we believe that there is a vacuum within the international law that specifically deals with cyber attacks on satellites. And the closest that we have with respect to our authority is the Talon manual and its classification of it as Article 24 Charter UN Charter's aggression.
And this satellite is registered in Moonland.
Immediately.
So how far the liability convention would apply?
Your Excellencies, specifically with respect to cyber attack, the responsibility would not arise on Moonlight. Again, because while most states enter into contractual obligations with respect to satellites, and these contracts are governed by outer space treaties. However, these treaties do not provide for the liability of a state in case of cyber attacks. They do provide for liability in cases of these satellites.
How does ICJ get jurisdiction to decide this issue?
Your Excellencies, the ICJ gets the jurisdiction because ICJ has compulsory jurisdiction over disputes that concern Article 2 Clause 4 of the UN Charter.
Right, it's an internal system, attack on internal system of cyber attack.
In that case, Your Excellency, we request this court to exercise its exceptional jurisdiction because it is important for this question to be determined so that the question regarding the violation of human rights, the humanitarian law, and the law of armed conflict, all of these can be settled.
Is it an international humanitarian law recognized cyber attack is also part of any international humanitarian law?
Your Excellency, cyber attacks as such are not recognized as a part of the international humanitarian law. However, Your Excellency, since the actions by mainland, the state respondent state, have been taking this defense that our satellites were harmed and this constitutes as an aggression. It was performed by a non-state actor whose acts we attribute to you. This is the reasoning that the respondent state has taken, and we are agreeing to it on the face-to-face basis. But even if we do not agree with this reasoning, that would only go against the respondent state. Indeed, yes.
So I was trying to understand the facts first. Trying to understand the facts. The Yoda who made the hate speech, so-called on a WhatsApp type of international system, created problems in the other state. There are two groups fighting after that. The Yoda denied it. In fact, the particular communicating agency is placed in a third state, not in either of the states. Their website was hacked by the Freedom Warriors. Freedom Warriors are non-state actors, a bit violent in their own way for the cause they believe in, residing in the mainland.
Your Excellency, that is not
in other countries.
They are located.
So they are the ones who are being attacked by it because their actions were causing your country, the other country, to use the artificial intelligence weapons to create a chaos of a bigger nature. Question of jurisdiction, and there are 2-3 issues from international point of view, which the Honorable Judge is trying to find out. One is, how do you attribute a non-state actor's actions which are not owned by the country, and in fact they are not even within their control? State responsibility articles you talked about attributability. They were strict in terms of government officials, agency directly related to government officials, and any other functionaries deputed or otherwise acting in terms of agency. And any actions taken by them within the powers of the agency will be attributable. If it is government officials and others also, excessive power, that is what actions they have done beyond their powers also could be attributed. But the way this particular thing has come about, the non-state actors are not even within the control of the country in which they are behaving. So attributability, first of all, they are not government officials, they have nothing to do with the government agency functions, and they are independent Naxalite type of people. and if they go ahead and do something, is the state able and willing to control them, or is it able and not willing to control them, or is it unable and unwilling to control them? There are three aspects by which non-state actors' actions can be looked into for purpose. This happened in so-called surgical strikes. You have not even mentioned anywhere about that. That is the most relevant example for you. And then these three concepts which I mentioned have nothing to do with state responsibility. They came out as a development of the law in the International Criminal Court and later adopted by the International Court of Justice in Cameroon versus Uganda, and then later Nicaragua case up to a point. So the question is for you to be able to justify that the actions of these non-state actors, like Hamas for example, which is the most latest case. So even if you take it that this group acted on its own, and even if I skip all these questions of attributability, I'm still not clear as to under what circumstances such a severe retributory action has been taken by the other country against you, which made you to come here. It's a question of proportionality, question of lack of your ability to control these guys are the ones. If you can argue on that, there is a case for you.
Your Excellencies, first of all, I would agree with everything that Your Excellencies have said, and that has indeed been our case in issue 2. We have said that the acts are not attributable to the state of Mamaland in any case. However, Your Excellencies, we still take the most liberal interpretation that the respondent state could bring in, pursuant to which we were arguing the proportionality of the said measure. Your Excellencies, the reason we mentioned the attacks of the 9/11 and post that the Ahmedabad attacks and not the surgical strike attacks were because in the attacks in 2011 there were no objections raised even by the host state of Pakistan, whereas in the surgical strike case such objections were raised. Now, Your Excellencies, with respect to proportionality that Your Excellencies have questioned me on, Your Excellencies, my time is over. May I request for extension? Your Excellencies, with respect to proportionality, we humbly submit that measures must be necessary, imminent, and proportional. With respect to necessity, Your Excellencies, as I was submitting, the harm in the present case is one of a satellite cyber attack merely, which may be remedied by other alternative means. In the absence, in let's say, even if there was an attack which was larger in quantum, even in that case, Your Excellencies, while the respondent state, with respect to jurisdiction, clearly contests that there should have been a negotiation, with respect to the cyber attack, which was also clearly not attributable to us, as Your Excellencies have rightly pointed out, did not even enter into a diplomatic conversation with us regarding the question. What they instead went on to do, Your Excellency, they attacked that country without even giving, and within their counterclaims, they do say that they gave us a notice. However, Your Excellencies, as visible from the paragraph 10 of the Moot proposition, the state of Mamaland was unprepared for such an attack. And in any case, even if we were prepared, Your Excellencies, we are a small country, underdeveloped, with weaker infrastructure. They are a developed country. Secondly, and they just submitted there was no necessity, so to say, to attack the country of Mamaland without any attribution, without any fact finding. But secondly, Your Excellencies, even with respect to the imminence, there is no imminent danger because even if the satellites were hacked once, even if such a cyber attack was carried out, the state of Moonland is a state, and even if we somehow understand that the responsibility is attributable to the state of Mamaland, the state of Mamaland is a state which is technologically inferior to the state of Moonland, and it is very difficult for us with resources that we have to conduct any attack or any violation on the soil of the state of Moonland. But lastly, Your Excellencies, with respect to proportionality, and for this, Your Excellencies, we humbly take you back to paragraph 6, where it is, just a second, we take you back to paragraph 8, Your Excellencies, where it is clearly mentioned that the satellite systems of the country of mainland were already not functioning, they were taken down. In the present case, Your Excellencies, even when they had to attack, which was not justified, the attack is not attributable to us, this should not have happened in the first place. But even when they carried out this attack, they used the AI-driven weapons of mass destruction, upon which the United Nations, in its 2015 meeting in the Convention on Conventional Weapons, has clearly advised against such autonomous weapons. More so, Your Excellencies, these were weapons of mass destruction. Weapons of mass destruction, in the most simplest language, have been defined by the ICRC as weapons that operate on either a scale of nuclear weapons or biological weapons. Even if we agree that such weapons would constitute a targeted attack because of AI systems that they work upon. Firstly, Your Excellency, these systems were inherently compromised because, as is clearly provided in the fact sheet, such weapons work through the use of antennas, work through the use of technology which was supplied by the satellites, which are themselves compromised, Your Excellency. Now, if the international humanitarian law, and if I may take you to the authority, at page 66 of the applicant companion,
Question was basically related to attributability. That's what my brother Rao was asking you. You just confined to that.
Your Excellencies, we say that even if this attributability is considered, this is an argument, Your Excellencies, we do not accept it. We say that even if this is considered, the attributability is considered, even in that case, the actions of self-defense would not hold ground because they were inherently disproportionate. This is, Your Excellency, our submission. We never agreed to the fact that the actions were indeed attributable.
Respondents have every right to protect their sovereignty. So our prima facie view is that it is an act of self-defense. So please try to distinguish how it is an act of external aggression and not an act of self-defense.
Your Excellencies, I would start from the very basic. An act of aggression is under Article 2, Clause 4. An act of self-defense is an exception to 2, Clause 4 under Article 51. Now this act of self-defense, they have claimed it against the applicant state. They agree to the fact that the attacks were not directly carried out by the applicant state. Their submission is that the attacks were carried out by a terrorist group called Freedom Warriors, and they somehow attribute the actions of this terrorist group to the state of Mamaland. We humbly believe and submit before this court that there is no reason to believe that such attribution may be held. For the simple reason, Your Excellency, as Your Excellency also correctly mentioned, that there is no government official that is involved. There's no direction by the government that is true. There's also no financing by the government that is true. And most importantly, as was decided in the Nicaragua judgment, no technical expertise.
If terrorist groups are operating from your country, are you not responsible for the wrongdoings of the terrorist groups
Your Excellency,
and for not controlling their activities?
Your Excellency, to answer that question, I will take some cue from the hints that the other judge gave me, which is, Your Excellency, even in the case where we are unwilling or where we are unable to control such activities, the only self-defense mechanism that would arise for the state of respondent is to claim that self-defense against the non-state actor, as was done by India in the surgical strike case. India did not attack Pakistan. India merely attacked that terrorist outfit that carried out the Pulwama attacks. In this case, however, Your Excellency, that non-state actor has not been attacked. It is similar to a terrorist attack, a small terrorist group, let's say 9/11 attacks happening, and then USA attacking Pakistan instead of Al Qaeda. This is the present scenario in this case, Your Excellency. Which is why we submit that firstly there was no attribution, but even if we consider, and secondly, Your Excellency, there's nothing to show that the terrorist outfit is present in our country. But even if we agree that they are present and we have not been able to control them, the right to self-defense does not arise against us as the state or against our citizens who have been suffering. It only arises against the non-state actor, for which the principle of distinction becomes important, Your Excellencies. However, that principle has not been followed, and civilians have been attacked. Your Excellencies, I see that my time has run out. I would quickly conclude with my arguments. Much obliged. Your Excellencies, since there was a violation of, since there is no attributability of the terrorist outfit upon the state, even if it was, since there is no necessity in the attack, no proportionality in the attack, and no due regard given to the law of armed conflict, as can be seen from the fact that the humanitarian aid was also blocked to the country of Mamaland. We humbly submit that there have been blatant violations of the international humanitarian law, and therefore I humbly conclude that this court takes it into record and set right the course of justice. Much obliged, Your Excellencies.
Agent just want to confirm whether the agent is audible to the bench. Much obliged. President of the court, Your Excellency, may it please this honorable court, this is the second agent on behalf of the state of Mamaland in this present dispute, and I'll be dealing with issue 5 and issue 6 as framed by this honorable court, which are with respect to the commission of act of aggression and act of genocide and the cardinal violation of principle of international humanitarian law and international human rights law by the state of Mainland, and lastly, the issue of reparation that arises with said violation. Now, if there are no preliminary inquiries from the bench, the agency's permission to proceed with issue 5. Much obliged, Your Excellencies. Your Excellency, with respect to issue 5, we shall be presenting fourfold arguments for the bench's convenience. Firstly, the actions of Mainland amounts to an act of genocide as per the Genocide Convention of 1948. Secondly, Mainland has committed an act of aggression. Thirdly, Mainland's action constitute a flagrant violation of international humanitarian law. And lastly, Mainland's action constitute a violation of international human rights law. Excellency, moving to my first submission, that the act of the state of Mainland amounts to an act of genocide in the present facts and circumstances. Your Excellency, for this I would like to refer to the compendium on page number 18, wherein the Convention on the Prevention and Punishment of the Crime of Genocide is given. Excellency, it is provided by the said convention that for an act to be considered an act of genocide, two elements needs to be satisfied. Firstly, the mental element, that is the intent to destroy in whole or in part a group protected by the convention, and secondly, the physical element, that is the killing members of the group or causing serious bodily or mental harm or creating such situation that may inflict such harm. Excellency, if we peruse the present facts and circumstances in totality, if we see it, what the state of England has done in the state of Mamaland in the name of self-defense. Excellency, even if we assume the arguments that has been put forth in the claims by the state of Mainland, that the actions of the terrorist organization are attributable to the state of Mamaland, even that cannot justify the act of genocide that has been committed by the state of Mainland in the present fact. Now, I'll try to demonstrate how the facts demonstrate that this was an act of genocide that was committed by the state. Your Excellency, it is clearly stated in paragraph number 11 that the state of Mamaland was not prepared for an attack, for a war. Now, against that, the state of Mainland deliberately indulged in the usage of AI-enabled weapons of mass destruction, which were inherently compromised, as has been already been argued by my co-agent. Further, Your Excellency, what has been done is that, as given in paragraph number 11, such usage of AI-enabled weapons of mass destruction caused death and destructions of more than 10,000 people, and along with that, it created a humanitarian crisis in the country, wherein the civilians of the entire country were left with no food or no water. And along with that, Your Excellency, if we see the claim submitted by the state of Mamaland, the state of Mamaland was not allowing the access to the humanitarian aid to the country of Mamaland. Hence, Your Excellency, if we see the facts and circumstances in total, it satisfies the standard of proof that has been laid by this very court in the case of Croatia versus Serbia. That is given in page number 16 of the compendium submitted by the applicant. That I'll read for the convenience of the bench. It reads as evidence of this intent of genocidal act is to be sought first in the state's policy, while at the same time accepting that such intent will seldom be expressly stated, but it can also be inferred from a pattern of conduct when this intent is the only inference that can reasonably be drawn from the acts in question. Excellency, if we see the facts in question, there cannot be any inference what has been done by the state of Newland in the state of Mamaland by creating such a humanitarian crisis, which will definitely amount to an act of genocide, as per the Genocide Convention, of which the state of Newland is a signatory, and hence it is binding on it. Now, Excellency, moving to my second limb of argument, that the state of Mainland has committed an act of aggression. Your Excellency, when the UN Charter was drafted, there was no precise definition of aggression which was provided in the Charter. Hence, the United Nations General Assembly came out in the resolution number 3314 of a precise definition of what would amount to an aggression, act of aggression. Apologies. Your Excellency, that is given in page number 11 of the compendium. I will read for the bench's convenience. It reads as in the Article 3 of the resolution that any of the following acts, regardless of a declaration of war, shall, subject to and according to the provision of Article 2, qualify as an act of aggression. A. The invasion or attack by the armed forces of a state of the territory of another state, or any military occupation, however temporary, resulting from such invasion or attack, or any annexation by the use of force of the territory of another state or part thereof. Second part of Article 3, Your Excellency, reads as bombardment by the armed forces of a state against the territory of another state, or the use of any weapons by a state against the territory of another state. Your Excellency, this particular definition of aggression as provided in the resolution was also adopted by this very court in the case of Democratic Republic of Congo versus Uganda, wherein the court relied on this definition to term the acts of Uganda as an act of aggression against the state of Congo. Further, Your Excellency, as has already been demonstrated by my co-agent, and for the brevity, I will not repeat the argument which has already been presented before Your Excellency. But in brief, the actions of England of using weapons of mass destruction in Mamaland's territory, for which it cannot claim the right of self-defense as been demonstrated by my co-agent, it clearly amounts to an act of aggression as per the definition given by the UNGA and adopted by this court, and it is a clear violation of Mamaland's sovereignty. Yes, yes.
We need a clarification. Sorry. Is there any alternative forum, assuming that it's not an act of aggression, but the issue like, crime against humanity? What would be the applicability of the Rome Statute and the jurisdiction of the International Criminal Court?
Excellency, the basic difference that would arise and why the Rome Statute would not apply, because a state cannot be held liable and be a party to the ICC. Therein, the acts which have been committed, as are clearly demonstrated in the Moot proposition, are attributable to the state. Hence, it was the state's policy to, in self-defense, to act the state of Mamaland. And as state of Mamaland cannot be made a party before the ICC, that is why the state of Mamaland has invoked the jurisdiction of International Court of Justice rather than the International Criminal Court, if it satisfies Your Excellency's question. Excellency, moving to my third limb of argument, that Newland's actions constitute a flagrant violation of international humanitarian law as envisaged in the 4th Geneva Convention and its additional protocol, which was signed by 196 countries, including the state of Newland, in 1949. Your Excellency, why the agent submits that it was a clear violation of international humanitarian law, it works on three grounds. Firstly, it clearly violates the principle of distinction, wherein a clear distinction has to be drawn between civilian population and its intended target, which was not done in the present case as stated in paragraph number 10 of the Moot proposition. Your Excellency, secondly, it has indulged in indiscriminate attack against the civilian population of the state of Mamaland and has violated the principle of proportionality, which is the cardinal principle of international humanitarian law. And lastly, Your Excellency, it has blatantly failed to fulfill its international obligation by denying the humanitarian access to the state of Mamaland, which was already dealing with such grave attacks in the name of self-defense. Hence, Excellency, this would clearly amount to violation of Geneva Convention of 1949, for which the state of England cannot state that it can has a right to derogate to such rights as they are non-derogable rights and a part of international custom. Excellency, with this, the Council submits that the state actions of mainland are clearly violative of international humanitarian law and international human rights law, as it has indulged in the acts of genocide and aggression. Now, if the bench is satisfied with its actions on issue 5, the agent seeks permission to proceed to issue 6. Excellency, the issue 6 is with respect to reparation that is to be granted because of the said violation that the agents have already demonstrated before the bench. Now, Excellency, the agent would like to divert the attention of the bench towards page number 7 of the compendium, which gives the precise definition of what would amount to a reparation, which was given in resolution 60/147 by the United Nations General Assembly. I will read the basic principles that has been laid down when on what basis the court would adjudicate as to what reparation is to be granted in terms of a violation of international humanitarian law. Your Excellency, the basic principles and guidelines for reparation provide that any reparation which is to be provided, it is to be adequate, effective, prompt, and proportional to the gravity of the violation suffered, violation done, and the harm suffered by the suffering state. Excellency, these resolution and the intended guidelines provided in said resolution was adopted by this very court in the case of Democratic Republic of Congo versus Uganda. Your Excellency, if we see the facts and circumstances of the present case, a clear case of full reparation is made out, which is also provided in Article 31 of the RCEPA, which says that if there is a violation of international law, there has to be a full reparation in terms of the proportional to the violation that has occurred. Now, Excellency, the agent submits that the full reparation that the state of Mamaland seeks, it would entail the following. Firstly, full restitution, that is to re-establish the situation that existed before the alleged violation by the state of Mainland. Secondly, for the sake of argument, if this court comes to the conclusion that restitution is not possible, then after a fact-finding mission is done after and a proper analysis is done as to what harm is caused, if the court comes to the conclusion that restitution is not possible, then adequate compensation for any financially accessible damage is to be provided to the state of Myanmar. Thirdly, yes, Your Excellency. Excellency, ICJ has the power to provide that reparation and has been providing such reparation in cases of grave violations of international human rights law. Excellency, the state has the obligation before the ICJ to oblige with the findings of the court, and if they are not, there can be repercussions to that. For example, if we talk about the case of Democratic Republic of Congo versus Uganda, the reparation which will Your Excellency, if the state does not comply with the ruling of the court, then it can refer the said ruling to the UNSC, where appropriate actions can be taken against the delicate state which is not abiding by the judgment of this honorable court. If it's satisfied. Excellency, for that I would like to refer to page number 7, where exact quantums are given as to for all what all compensation should be provided. I'll read for the bench's convenience. Excellency, it reads that On paragraph number 20 on page number 7, compensation should be provided for any economically accessible damage as appropriate and proportional to the gravity of the violation and the circumstances of each case, resulting from gross violation of international human rights law and serious violation of international humanitarian law, such as A. Physical or mental harm, B. Lost opportunities, including employment, education, and social benefits, C. Material damages and loss of earnings, including loss of earning potentials, D. Moral damages, E. Costs required for legal or expert assistance, medicine and medical services, and psychological and social services. Now, there must be a doubt in Your Excellency's mind as to how we quantify the number as to what would be the granted for this. For this, Excellency, the International Court of Justice has resorted to making equitable assessment based on the facts which are presented before it. Hence, it will provide a lump sum global sum for each head under which a reparation is asked for before the court. Hence, they can be to the exact quantification as to this will be the quantum for this will be the for this, but a global sum is provided in its entirety to the state which is asking for the reparation.
The agent like in the court about any decision that's what should be taken.
Yes, Your Excellency. Your Excellency. Yes, Your Excellency. The same thing.
It is the decision, various damage is provided by the ICJ.
It is the first thing that was provided was the factory at Chorso case of 1925 by Permanent International Court of Justice. This is a court of International Court of Justice. But a more relevant decision was the case of Democratic Republic of Congo versus Uganda, which is a recent. You said, Your Excellency, in the Porto channel case, compensation was not provided, although it was found that there was a clear violation of sovereignty of the country, but no compensation was provided. Your Excellency, if I talk about the reparation in the case of DRC versus Uganda, what happened was the judgment on merits was given in 2005, but the judgment on reparation was given later. And since there was a considerable difference of time between these two judgments, the court had the difficulty which Your Excellency highlighted that how do we quantify, because in a war-torn country it's very difficult to find the adequate evidence to quantify the particular reparation. Hence, for that the court came to the global concept of global sums and equitable consideration upon which the court finds the reparation. For Excellency, for example, in a particular head, I don't remember the exact figures and do not like to mislead the bench, but I just remember that under one head, for example, the DRC was provided with a compensation of 20 million US dollars. It was under one head. So under different heads, different compensation was provided, which the agent is not referred and would not like to mislead the bench. If it satisfies Excellency's question. Excellency, the last two points that was left over in the case of reparation, for which we are asking. First was the guarantee of non-repetition of such violations by the state of mainland in the name of self-defense, which would require specific measures or specific guarantees and assurances from the state. And lastly, the reparation of satisfaction, which would entail an official apology from the state and prosecution of the people concerned who were chain of command and were responsible for the commission of said crimes. Excellency, with this, the Council concludes arguments on issue 6. Now, if the court is satisfied with the agent's submission, the agent seeks permission to proceed with the prayer. Much obliged, Excellency. Excellency, the agent humbly submits that firstly, on jurisdiction, this court has the requisite jurisdiction to hear this case. On merits, first, the use of force by mainland amounts to an act of aggression. Secondly, mainland has committed an act of genocide as per the Genocide Convention of 1949. Thirdly, mainland's action constitute a grave violation of international humanitarian law and international human rights. Thus, it is liable to provide full reparation to the state of Bangladesh. With this, Your Excellency, the agent submits his case. It was an honor to plead before this court. The agency's excuse of this court.
Turn it to the judges.
clearly audible to the bench? Okay. With the permission of Your Excellency, shall the council start? Good afternoon, Your Excellency, Mr. President. My name is Priyachi Sharma. I will be representing the respondent, the Republic of Mahindra, along with my co-agent, Mr. Rajavardhan Singh Razada. We both will be speaking for a total of 27 minutes, and we will be reserving 5 minutes for rebuttal. I will be dealing with issues 1, 2, and 3. Issue 1, which pertains to the jurisdiction of this court. Issue 2, which is pertaining to the state responsibility of the state of Namaland for the actions of widow warriors. Issue 3, which pertains to the act of mean land amounting to self-defense and not the use of force. My co-agent will be dealing with issues 4, 5, and 6. 4, which pertains to the responsibility of mean land for the actions of the stakeholder, Calyptex, and RADA. Fifth, with respect to no breaches of cardinal principles of IHL, human rights, and no genocide convention or war of aggression. And lastly, we owe no reparations to the state of Mahindra. We are also joined by our of counsel, Mr. Kushan. With the permission of the council, Your Excellencies, the council seeks permission to start with the first issue. The first issue, with respect to the jurisdiction of this court, it is an established principle of legal jurisprudence that jurisdiction is that legal power delegated to an international court to adjudicate upon a dispute. The court must exercise this unless there exists a valid reason not to exercise this power. The council submits that there are 5 valid reasons as to the inadmissibility of the claims presented by the state of Nagaland, due to which the bench must restrain from exercising the jurisdiction granted to it. Firstly, due to the non-joinder of a necessary party to this case, that is Moot. According to the case of monetary code, Your Excellency,
How do you relate a non-joiner party with jurisdiction?
Your Excellency, we relate non-joinder of party with inadmissibility of claims.
That is all changed. What is it? What do you mean by jurisdiction then?
Your Excellency, we are accepting, since it is a compulsory jurisdiction of this court, and according to the clarification to the provision, to the preposition, we have consented to the compulsory jurisdiction of this court. We have questioned.
How do you determine the jurisdiction, whether the court has jurisdiction or not?
In the case of ICJ, Your Excellency, the
Yes.
consent of the parties determines the jurisdiction of this court according to Article 36 of Statute of ICJ.
No, that will not create a jurisdiction.
Your Excellency,
They have consented, yes, ICJ, but that will not create a jurisdiction. On what basis the jurisdiction is created?
if Your Excellency is referring to the subject matter of the
Yes,
case.
exactly, subject matter. Because there is no dispute, both parties have consented to ICJ. There is no dispute, right?
Yes, Your Excellency.
Now, how the subject matter, based on what basis you say that there is no jurisdiction?
Your Excellency, we are saying that the subject matter presented to by the state of Nagaland is not admissible because they are raising claims against private entities, they are raising contractual violations as claims which are not the subject matter jurisdiction of this court, and hence the court must restrain from exercising the jurisdiction.
They argue that state responsibility and attributable.
Okay. Is Your Excellency asking the council to refer to the attribution of conduct of freedom warriors to the state of Nagaland?
They would say that ICJ is having jurisdiction because of state responsibility. Do you think so?
Your Excellency, to the best of the council's knowledge, the council believes that since mainland accepts the fact that we have consented to the jurisdiction of this court, the only issues that remain are the admissibility of the claims before Your Excellencies. With respect to state responsibility,
Can the ICJ decide a matter without jurisdiction on admissibility? What are the difference between the admissibility claim and court having a jurisdiction?
Your Excellency,
maybe the court may have a jurisdiction, but claims may not be admissible.
absolutely, Your Excellency, and that is what we are raising here. So the jurisdiction was granted to
And then there are argument that the court lacks jurisdiction would fail.
No, Your Excellency, since jurisdiction with respect to Article 36 is granted to ICJ when two parties or a party refers a dispute and is consented to by the other state against which the dispute has been raised. And the admissibility of the claims is respect to the subject matter that we believe is better suited for another forum. Your Excellency, because since according to the clarifications we have consented to the jurisdiction, we had no case arguing the inadmissibility of claims because of lack of jurisdiction of ICJ. So the council thought it fit to question the subject matter that they are presenting before the Your Excellency. Very well, Your Excellency. So with respect to the moonlight being a necessary party to this case, the two primary contentions of the state of Nagaland are against Bratap and Galactics. Both are headquartered, the place of incorporation of both the countries and the state of Moonland. Hence, its interests before Your Excellencies decide to adjudicate upon this dispute, their interests must be taken into account because of the said incorporation of both the private entities.
Merely because the satellite is launched from the moonland and it is registered, it is. Do you mean to say that they also should be party to this issue? Please.
Your Excellency, we are contesting the fact that we are not responsible as a state for the actions of Bratap and Galactics. But we do know who is responsible, that is the state of Moonland, where the said entities are registered. So in that case,
How does the registration would have an impact regarding liability or any other accountability or responsibility under international law?
Your Excellency, well, the council would admit
Which
that
convention covers that registration of satellite?
the council please ignorance with that specific question, Your Excellency. But the council will, however, argue that the registration of a particular company is with respect to the domestic laws of that state, and hence that state exercises as to what will be the integrities of the registration of that company, and they have effective control according to Article 8 of RCLA, which has been repeatedly referred to by my learned friend, and that is why Moonland must be adjudicated as a party in the present dispute, and not.
Is there any register is maintained for registration of satellite?
The council pleads ignorance, Your Excellency. I will certainly look into it and get back to you.
Yes.
Thank you, Your Excellency. So, since the claims of the interest of Moonland form the core subject matter, the council insists that the court must restrain from exercising jurisdiction in the present case. Additionally, since Mamaland has claimed contractual violations against Moonland, the contractual violations which pertain to the rights and persona of the parties, Mamaland and Moonland, cannot form the subject matter of the present case, and hence the court must restrain from exercising its jurisdiction. Secondly, Mamaland did not initiate negotiations with Moonland before coming to this court, and thus the claims raised by them are not right to be settled by this court. The council would try to bring the attention of your excellencies to Article 33 of UN Charter. And I quote, the Article 33 of UN Charter states that the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall, first of all, seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, so on and so forth. The Council begs to submit that Article 33, along with the established jurisprudence of this court in the case of Georgia versus Russia, specifically states that before coming to ICJ, negotiation or any form of alternative peaceful method of settlement must be resorted to first by the parties before coming to the judges for adjudication. That has been believed to be a better way of settlement of disputes, and thus the claims presented by the state of Nagaland are not right to be adjudicated by this honorable court. Thirdly, the claims raised against Mr. Yuda cannot be adjudicated before this court because they form part of the domestic legal setup of Mainland. Mr. Yuda is a national of Mainland. Everything alleged against him is something that the legal system of Mainland is effectively dealing with. And that is something that the domestic legal systems of Mainland has the exclusive jurisdiction of since he is a national of that country. And him being a single individual private entity, the claims against him cannot be adjudicated by ICJ. They are to be adjudicated by ICC, which is the next contention of the Council, that ICC is a better suited forum, as they have also raised contentions of violations of genocide, or war of aggression, which are under specific provisions of the Rome Statute, as also mentioned by Your Excellency in the previous arguments of my learned friend, and hence ICC is a better suited forum, and thus the court must restrain from exercising its jurisdiction. If Your Excellencies have no questions with respect to first issue, shall I? Believing that Your Excellency will refuse to exercise their jurisdiction, hypothetically, the submissions to the issue 2 are as follows. Before we start with the submissions to issue 2, the Council would like to bring attention of Your Excellencies on page number 11, sub issue D, paragraph 1. There are 4 UN Security Council resolutions mentioned with respect to anti-terror obligations of parties which are orga omnes in nature. They are against all. These resolutions mandate that all states to refrain from providing any form of support to entities or persons involved in terrorist acts, deny safe harbor, and take necessary steps to prevent its commission. This principle, read with Article 2 of RCEPA, states that RCEPA specifically mentions that not only actions but omissions are also attributable to a state and for establishing state responsibility. We contend that the state of Nagaland failed to fulfill its erga omnes anti-terror obligations against not only mainland but the world in general, which led to us having to step in our self-defense and the violence of freedom warriors stepping over from the territory of Nagaland to the territory of mainland, and has led to the present dismal state of affairs. And hence we attribute the conduct of freedom warriors due to their negligence and omission in fulfilling their obligations, their anti-terror obligations, and hence the conduct of freedom warriors is attributable to the state of Nagaland. Secondly, we have referred to the talent manual of NATO, and we understand that talent manual is not binding in nature, but the council would like the court at this juncture would like the court to would bring the attention of this court on the fact that there are 4 sources that the court can refer to for adjudicating upon a dispute. The first source states that publications of highly qualified jurists can also form part of the adjudication of this court. And referring to that, along with the fact that we urge the court to consider the submissions of the council in respect of public conscience and equity. We are referring to Talent Manual and we allege that Nagaland has failed to fulfill its obligations under the Talent Manual, also under customary international.
Plan itself is not a binding. It says that it's only a compendium of what existed. The Talent Manual itself will not create an obligation.
It is not Your Excellencies, but Your Excellencies can very well refer to Talent Manual because 31 NATO countries already refer to it for adjudicating for.
That's only academic literature, Talent Manual, nothing else.
Yes, Your Excellency, but since we lack any hard law with respect to cyber warfare, we are trying to make do with what we have. And Talent Manual is the best available material according to the personal.
It's only an academic resource.
Yes, Your Excellency?
It's only an academic resource.
Yes, Your Excellency, but it still forms part of the sources of law that the ICJ can refer to for adjudicating a dispute under Article 38 of ICJ statute. Read with the fact that ICJ has the inherent jurisdiction to deal with the present subject matter according to their discretion. And the Council can only argue that Talent Manual lays down a certain set, and not only Talent Manual, we have tried to establish responsibility under RCEPA right with the UN resolutions which were binding in nature. The Talent Manual is, we understand it is persuasive in nature, but we will, the Council would seek permission of the school to refer to it so as to establish a comprehensive
You are not arguing that the basic point, which there is it not falling under the state responsibility as far as you, do they attribute to you that?
The actions of the 3 entities, Your Excellency?
Yes.
Your Excellency, the Council can deal with it, but the Speaker 2 of the Respondent is dealing with issue 4, which specifically.
Not issue 4, the basic issue of the jurisdiction on the state responsibility. You say that it's some private entity or some other who have done this.
Yes, Your Excellency. So, if the Council understands Your Excellency's question well.
That is a basic issue now. When you are relating to the issue of jurisdiction, that is a basic issue. That is a basic point you have to answer first.
that whether mainland has take responsibility for the actions of the private
Yeah,
entities.
exactly.
Your Excellency, we have dealt with that issue in issue number 4.
Okay.
If mainland has responsibility for actions of,
Go ahead. Yes. Proceed.
and if Your Excellency,
Now you can proceed.
okay, Your Excellency. Right. And something that Your Excellency presented in the before case that the Council would deem fit to start with before starting the discussion current manual. If non-state actors' residents or state of residence effectively counters terrorism, self-defense is completely necessary on the part of mainland. In the present case, not only they omitted on their anti-terror obligations, which shows their incapability and unwillingness, as my brother friend has submitted, that they are a very small country. And
What are the parameters? How can you distinguish between self-defense and international wrongs?
Your Excellency, if the Council is understanding the question well, if self-defense is not acted with respect to Article 51 of the UN Charter, then it will result in an unjustified attack and it will result in an international law on the part of me. And the unwillingness on part of Mama Land to cater to their anti-terror obligations resulted in mainland having to step on and protect not only mainland but Mama Land as well from the terrorist outfit persisting in their country. So, increasingly, what we want to say that we understand that it is a developing country, so it was incapable as well of dealing with the terrorist outfit flourishing in their territory, and hence our self-defense, which is dealt under issue 3, but the council, to set the base of your excellencies, dealt with it first. And according to current manual, the self-defense is justified in the said case when the state of residence of the non-state actor is unwilling and incapable of catering to it to establish its anti-terror obligations. Additionally, Mamaland was responsible for the actions of freedom warriors as it violated the principles of due diligence, calling for defensive action from the state of Union. What is uh, what is presented before your excellencies is the fact that current manual specifically lays down due diligence measures to be taken by the state of Mamaland, which they fail to do so because their resources, as supplied to them by galactics, were misused by freedom warriors. We understand that they were in any way capable of not being able to control the actions of freedom warriors, but they could have control and misuse of their own natural resources, which they miserably failed to do so and we had to step. And hence, all these violations lay down the fact that there must be attributed responsibility for the actions of freedom warriors and the subsequent commission of international wrongdoing. Thirdly, does the act of mainland amount to self-defense or is it an act of force? For establishing self-defense under Article 51, what we must establish is the essentials of an armed attack. The armed attack, firstly, there, according to yes. Firstly, there must be an act or series of acts of such gravity that they can be deemed as an armed attack. Secondly, the armed attack must have a significant connection to the state where the act of self-defense is to be carried. In the current situation, the act of data breach, data manipulation, and the hacking of communication satellites and the direct armed attack show the series of acts and the gravity of the threat to pose to the people of mainland undeniably constitutes an armed attack. Secondly, freedom warriors operated from the territory of Nagaland, showing a significant connection to the state meeting the threshold as established by Article 51 of the UN Charter. And thus, we sufficiently established that what we did was well within the parameters as established by Article 51 of the UN Charter. Subsequently, as has been also mentioned by my learned friend, we also refer to the actions of United Nations taken by the 7/11 attacks, and their actions against non-state actors were subsequently accepted by the United Nations Security Council, and we refer to the said resolution in furtherance in justification of our action against the non-state actor freedom warriors persisting in the state of Myanmar. Third, the use of AI weapons of mass destruction was legitimate and necessary due to imminent threat that loomed over me. At this juncture, what the Council would like to present before the Excellencies is that my learned friend submitted that the use of AI weapons of mass destruction was unwarranted because the fact that they were using AIs to use AIWMDs, and the antennas were themselves compromised. So weapons of mass destruction resulted in non-proportionality of the said acts, and hence we must be held liable. But the council humbly contests the fact that we understand that the security might have gotten compromised of AI weapons of mass destruction, and we immediately instructed Galactics to shut down terrorist communications to the state of Mamaland so that we can cater to the said compromise. And we did this as soon as we so as to not render the AI weapons, the use of our AI weapons fruitless in the state of Nagaland, to reduce the casualties, if there were casualties, as much as possible.
Measures you have taken?
With respect to the armed conflict, Your Excellency,
You said using the weapon of mass destruction. What measures you have taken using it?
the first measure was using a precision. We are a pioneer in this field, Your Excellency, as has been duly established by the proposition. We understand how a weapon should be used so that it mitigates any collateral damage, any unfortunate collateral damage, to the maximum extent as possible. With respect, under the light of this fact, we used AI weapons of mass destruction in a way that reduced the casualties, and so as to also elaborate upon the fact that they have mentioned 10,000 number, including women, children, and elderly. They have not specified how many women, how many elderly, how many civilians, how many combatants were injured during this attack. And in the absence of the said fact, it cannot be duly established that whatever we did was disproportionate, or we acted out of necessity. In the light of these facts, we also would like to establish that our attack was proportionate and necessary, because we were posed with a grave and imminent peril at hand, because freedom warriors had hacked into the systems of BRATA, and we had 20 million in a country of 45 million. Your Excellencies, 20 million data, 20 million users' data was in the hands of a terrorist outfit. And RADAR not only collects messages, but it also collects user locations. Our security, our territorial integrity, our unity was at a grave threat, and we had to act immediately in furtherance of the said necessity, and hence we used the said weapons to counter the threat at hand.
Is the agent admitting that the weapons of mass destruction were used at the behest of the respondent nation?
Your Excellency, we did use AI weapons because we, being a pioneer in the said field, knew how to best use them, how to make the best use out of them so as to minimize any unfortunate casualties that could take place, because it was a state of war, Your Excellency. We had lost lives as well. We had been subjected to cyber attack, not only cyber attack, but a terrorist attack, a physical terrorist attack as well. On two fronts, we were fighting, and we had to do something about it, and we had to do something about it immediately and urgently. And hence, we used AI weapons. And to continue towards the precision, we had to ask Galactics to shut down operations in the state of Mamaland so that our weapons are not rendered fruitless. That concludes my submission, Your Excellency. If Your Excellencies have.
This terrorism has no boundaries. So Mamaland has already banned these freedom warriors, and it is declared as terrorist outfit. So how do you justify attacking the petitioner when they have already banned this outfit?
Your Excellency, in the absence of the fact that any other country has banned the said organization, we believe that if Mama Land chose to ban them, they must have had sufficient knowledge with respect to the organization, with respect to the how the freedom warriors persist. And that has led us to believe that freedom warriors must have existed in the territory of Mama Land for them to do a positive act and ban them, and not do anything further, but ban them at least. Step in the right direction or not, if you were asked, Your Excellency.
Are you arguing that mere prohibition is not enough? There are further actions of due diligence are required to control their actions from harming others, and in the absence of that, their actions a cause of action for your country? Is that what you're arguing?
Absolutely, Your Excellency. That is precisely what the Council seeks to submit before Your Excellency. Is that this is why we had to step in, because Mamaland being a small developing country, us being a developed country, we had to come rescue our little brother, and we had to do that urgently.
Council, you're so fair.
We tried to be, Your Excellency. We tried to be. If Your Excellencies have no other.
Already banned the organization. In what manner they can control the activities? They have banned the organization. The organization does not have any activities in that country. So, how do you think they are responsible for any illegal acts carried out by that organization?
With respect to the present proposition at hand, Your Excellency, they allowed their satellites, as was given to them by Charactex between their contractual obligations, to be misused by the state of by freedom warriors, which led to their cyber attack on our territory. The least they could have done is protect their natural resources from being misused by a terrorist outfit at that. That is something that they could have done, Your Excellency. Just stopping short of doing this, they have given us a cause of action to invoke Article 51 of UN Charter, Your Excellency. If Your Excellencies have no other questions, please ask. It was truly an honor to argue before Your Excellencies. Thank you. May it please.
To the Honorable President of the Court, Your Excellencies, may it please the Court. My name is Rajavardhan Singh Rajavat, and I will be representing the respondent, the Republic of England, for the next 27 minutes, and I will be submitting the final 3 questions before this Court. Your Excellencies, the very first submission, that England cannot be held accountable for its responsible use of autonomous weapon systems. And to this avail, I quote from paragraph 6.1 to 6.4 of the report of UN's rapporteur Damien Courtier on the emergence of lethal autonomous weapon systems, where it was held that the conformity of lethal autonomous weapon systems within the international humanitarian law is met if the lethal autonomous weapon systems are well designed and well programmed, so as to execute surgical strikes aimed solely at military targets. Further, within that report, it was also that if the judgment calls are as to whether the attack satisfies the principle of proportionality or not, should be made on the basis of values and interpretations other than numbers and indicators. These values and interpretations, Your Excellencies, are highlighted through the conditions that Mamaland let happen and that England found itself in, and the definitive aim with which it carried out the attacks. Further, Your Excellencies, the advisory opinion of this very court in the 2018 report, where the England's attacks were, we contend that the England's attack are in consent and in tune with the advisory opinion of this court, where this court opined that in view of the current state of international law and of the elements of fact at its disposal, the use of weapons of mass destruction may be termed lawful in an extreme circumstance of self-defense, in which the very survival of the state is at stake. Your Excellencies, we contend that England fulfilled all its international obligations as it carried out the attacks, and its actions were within the advisory opinion's limits set. And to that avail further, I contend that we were faced by an adversity in the face of freedom warriors, Your Excellencies, who exploited civilians and cutting-edge technology to conceal their identities and operated facelessly. And their attacks against our digital infrastructure and of other two nations, the Moonland and we contend Marmaland as well, and to confront this level of sophisticated and unconventional threat, where traditional international law is not clear, Memeland was compelled to resort to the use of autonomous weapon systems. This was important because this particular circumstance necessitated innovative and targeted responses, which were only possible through the use of artificially intelligent WMDs, who we contend are very precise and well programmed, so as to attack only the military targets instantly. Because, Your Excellencies, and I move forward with my submissions, that these artificially intelligent weapons are made so as to take away the human component of error, where the human eyes might fail in understanding that this is the target we have to attack. These artificially intelligent technologies, which we being the pioneer, as accepted worldwide, have created, these technologies can interpret such threats because at the pre-deployment stages, these are treated well with all the knowledge that we have incurred through intelligence. And thus, these particular weapons were able to constitute attacks that were directly on the targets and were immediate as well.
How the algorithm of artificial intelligence could find that data that
Your Excellencies, these reports are based on trial and error, and our country, being a pioneer, puts great emphasis on coming up with technologies that have great use case in the global system. We, in tandem with Galactics, who are also providing satellites throughout the world, especially to the state of Namaland, understand that technology is being used and should be used for the betterment of the causes that we are facing. That's my submission, Excellencies. Moving further, Excellencies, we contend that Memeland's instruction to shut down all satellite communication channels going to Mamaland align with the Outer Space Treaty. Specifically under Article 3 of the Outer Space Treaty, which governs the functioning of satellites, Your Excellencies, it is emphasized that outer space shall be used only for peaceful purposes. The principle of peaceful use, Your Excellencies, of outer space is universally acknowledged as a customary principle of international law. And we, as the Republic of Memeland, only carried out these attacks as it was fulfilling our responsibility. The responsibility that the state had to prevent hostile conduct carried out by these entities with their operation were forming the part of the state's national activities in outer space. And under the use at Bellum, Your Excellencies, the targeting of satellite is justified as an exercise of the right of self-defense that we have and avail under Article 51.
is it anywhere in outer space treaty allows for such an activity by any other country?
Your Excellencies, the International Committee on Red Cross, when talking about the use at Bellum, had allowed that the use of force in certain modicum so as to complement the use case of other conventions can be done. And within a convention, the articles on the space treaties also form the part.
The very idea of outer space treaty is to avoid conflict among the countries and use this outer space for peaceful use. Then how do you refer to the outer space treaty for this?
Your Excellencies, to ensure that the satellites were still being used for these purposes, we did not use any satellite to carry out these attacks, but we had to stop the Freedom Warriors' infiltration of these satellites to ensure that they were still used for peaceful purposes, and that's what we contend.
Is there any conflict mechanism provided under outer space treaty?
Not that I know of. I'm not aware of that, and I don't believe that there is.
Yes, proceed.
Yes, Your Excellencies. As I was submitting that our state was fulfilling its responsibility as a matter of self-defense, and further, this action taken by us served an essential function. And this essential function was to stop Memeland from accessing these satellites. Because I would like your to bring your all attention to a certain point, that if we possessed these artificially intelligent weapons of mass destruction and freedom warriors had infiltrated satellites and were carrying out cyber attacks within mainland, Your Excellencies, and had access to our cyber system, what is to suggest that they did not or could not access these AIWMDs and warheads that we possessed and could have remotely controlled them to wage a war of impeccable proportions across the world? This threat is what we claim is be avoided. And I think the values and interpretations, as I reported earlier, must include the threat and danger these actions of mainland helped in avoiding. And thus, our actions were an essential function of the responsibility. Your Excellencies, moving further, there's one more point within this issue as to mainland's instruction to shut down the satellites were also a form of necessity within the meaning of Article 25 of the Articles on Responsibility of State for International Wrongful Acts, within which, and I also submit that the statement of Ms. Lecky of Galactics, the very statement that even they were unaware that these satellites could be used as a frontline warfare system is sufficient to understand the nature and the gravity of the system. And as to an earlier question raised by this bench, as to how did we ascertain our beliefs that freedom warriors were present in Mamaland, is by the fact that the very providers of satellite who provide satellites to Mamaland, their first action, and without any interference by us, was to block the satellite information channels to Mamaland when they were faced with this cyber attack, which is indicative and suggestive enough of our apprehension that we have already had intel reports to believe their existence in Mamaland is substantiated right here. If Your Excellencies have no further question on issue 4, I'd like to move on with my fifth issue.
See, act of self-defense has to be commensurate to the act of aggression. So you indulged in violation of human rights. Your action has resulted in loss of life. So as against cyber attack, your act of causing loss of human lives appears to be in excess of your right of self-defense. Please give clarity on this.
Yes, Excellency. This Republic of Mainland, their cyber systems were hacked. We tried to gain access back to them, as it is suggested by our African co-partners. It was not as easy as disconnecting a computer plug. These things and these technologies require, and as we being the pioneer, a certain level of technical expertise to gain access to the satellites, which apparently freedom warriors possessed. Now, having hacked the system, they did not stop there. They carried out an attack on mainland, where we also lost lives and properties, Your Excellencies. This, if was not enough, we also preempted that their actions will not stop. These are terrorist groups, and they might continue to attack whichever country they get access to. And through these satellites, they had a position, they had a chance. And what should suggest that they'll not use it? And this preemption, Your Excellencies, is what we claimed as a self-defense, not only of our country, but of the global sphere that we are a part of.
Can
Yes, please.
I, following the question of our honorable colleague here, the freedom warriors are a terrorist group. I don't know how widespread this terrorist group is operating on an area in the country, and how big a country is that we have not. Your question about, your problem about Maryland, if I take it, is that they are not able to control these guys, and therefore this is happening, and therefore you went ahead and took it as a attributability and then took a self-defense action. But you have used an artificial intelligence machine, machinery guided by artificial intelligence on which you have no control. Once it is unleashed, it can do enormous damage, and it's not a precise way in which you, because you are trying to explain it, can also do some precise and all that. But if it is doing precise and all that, why are you using a weapon of mass destruction which has no, by very definition of it, it is a mass destruction weapon? So that is disproportional in its own right. And as the plaintiff argued, if you want to target even if it is a problem and otherwise a reasonable thing for you to act in self-defense, you could have acted only on the terrorist operational areas, but entirely attacking the entire country and then trying to block and then finish off their satellite systems, communication systems, all that looks obviously a disproportional act. It's not tailored to the threat perception, the threat that the actual use of force, if you think so. And the attributability is a question mark here anyway, because we don't know whether they're able and willing, and otherwise those things are not very clear in the arguments that came out. But the fact that you used a weapon of mass destruction through artificial intelligence technique itself seems to be completely out of proportion to the current activity. Unless you argue, unless you try to convince us that these fellows are spread all over the place and they're unable to really distinguish between who is a civilian, who is not a civilian, and who is a terrorist, who is not a terrorist. Like Israel is arguing that they are sitting in hospitals, they are underground tunnels, and they're all over the place, and I can't do this, and I can't do that, and that kind of thing. Unless you convince me on that, you have a weakness. Your point is not going to convince. There is a problem about proportionality.
Your Excellencies, there are certain points of responses. Yes, ma'am.
Of the question asked me.
Yes, ma'am. Yes, ma'am. Yes, Excellencies.
So you said your mainland is admittedly a very good country and all that, and you have used artificial intelligence, you have developed artificial intelligence, weapons for mass destruction. So what are the you haven't outlined as to what are the steps taken by you to identify the particular perpetrators whom you wanted to target. You have just used it and it has affected so many people. So therefore, you haven't shown the proportionality or equality of the self-defense. Self-defense may be justified. He is justified, but then it should be equal or proportional. So you haven't shown what are the steps taken by you to see that it's proportionate and that and you have also stalled the humanitarian aid. So how does that justify your act of self-defense?
Your Excellencies, first on the humanitarian aid part, it is not the Republic of England that stalled the humanitarian aid. It was a mere indirect impact of the fact that their communication channels were banned. It is a claim that they've claimed, and we contend that we are always there to help each country and nation. Further, the fact that the humanitarian aid could not go out of the Republic of Mamaland is a case attributable to Galactics, and who provides the satellite services to them under a private contract. The nature of a private contract is such that it could be breached, and another state could not be held responsible for that. As to the first question, Your Excellencies, weapons by their nature are meant for destruction. Weapons of mass destruction, by their nature and application, conduct such attacks wherein the existence of targets is compounded within an area. And quite contrary to the claim that we're supposed to make, we're making this claim that we did find out that this explaining as to how we employ these AI technologies would also went into fact creation zone because the preposition is silent on these facts. But we do contend that based on our intel reports, we had precise locations, we had compounded locations, and in the pre-deployment stage, when we go into executing these weapons, into technologizing them, there is an impact, there is a particular reasonable approach that we take, and that approach was shown. Further, we agree that there was a loss of lives, the lives of terrorists. The terrorists who were causing others to lose their lives, creating tensions, causing deep fakes. We have reasons to believe that the deep fake of Mr. Yoda was also an action of freedom warriors, which caused ethnic conflicts all over the world. And this loss of life of the terrorists is an aim that we achieved. An aim and also an essential aim of which should be of Mamaland as well. Your Excellencies. Your Excellencies, based on our submissions for issue 3rd and 4th, it is clearly distinguishable that each action taken by England was based on its state responsibility and the necessities it had to face, and thus we contend that there is no breach of the international humanitarian law and the human rights law. Your Excellencies, this is because the England's actions satisfy a very basic principle of necessity. This principle avails and allows countries to act in a way which might be indifferent with the UN Charter in whole, but is allowed under Article 51 because it understands the meaning of necessity. Your Excellencies, this necessity that we claim emerged and emanated from the grave and imminent threat that we faced from freedom warriors, and we also agree that this was the only recourse which was available to us. Any other recourse would have taken too much time for us to neutralize these organizations which had access to the AIWMDs through the cyber security breach that it carried out, as I asserted. Further, Your Excellencies, the human rights treaties in particular do not exclude the invocation of necessity, and the derogation clauses duly acknowledge that unusual situations may necessitate temporary limits on human rights that would otherwise be unacceptable. The loss of communication on part of Mamaland as an indirect impact of the actions of Mainland allegedly is, if anything, a temporary limit which will be restored soon. Further, the respondent submits that Mainland took utmost precaution to distinguish between the freedom warriors and civilians, and this is our contention that the respondents deployed strategic AI tools, as Your Excellencies asked, which caused minimum collateral damage and maximum destruction of the terrorist outfits, because the sending of a military on foot does involve a lot of necessary complications and an unnecessary additional loss of lives and an overtly long perpetual state of war, which is something that we did not want and which would not have necessitated the actions of freedom, the actions against freedom warriors that we wanted. Additionally, Your Excellencies, the UN Security Council, in its resolution under 2325, under which it was made a common duty of all the states to make sure that no weapons of mass destruction, no technology, and no trade should end up in the hands of terrorists. And this is what we were avoiding as a means of necessity, Your Excellencies. Preventing these non-state actors from acquiring and using weapons of mass destruction is among the most important responsibilities of the international communities. And this I've quoted from the same resolution, Your Excellencies. The respondent was acting in furtherance of this very resolution. Further, Excellencies, although we consider that human rights treaties continue to operate in armed conflict, the international humanitarian law is better suited to the realities of armed conflict. And to reconcile this opposition, this very court has consistently relied on lex specialis doctrine, and international humanitarian law is an extension of the human rights law in war situations. And as we have already maintained that we did not violate the international humanitarian law, there arises no question of the violation of human rights law. And that's what we contend. Your Excellencies, another point of contention, which is very important to our issue 5th, is that it must be noted that the 10,000 persons allegedly killed by Mainland in retaliation to the armed attack by freedom warriors, the women, the children, and the elderly were included and did not constitute the primary casualties, Your Excellencies. Thus, this action of Mainland is permissible under the IHL and does not constitute a violation, as maintained by the state of Mamaland, contrary to their allegations. Further, as to the claim maintained by the state of Mamaland that Mainland has committed genocide against Mamaland, we respectfully submit that this claim alleging genocide misses the essential element of intent, which is nowhere certified, which is nowhere maintained, which is nowhere indicated. We were acting strictly against the terrorist outfit, and we carried out our attacks in maintainability of that particular aim that we carried. It was not an act of genocide. We did not single out a particular group to exterminate them. If Your Excellencies have no questions on this point, I'd like to move on to my sixth. Thank you, Excellencies. Excellencies, we contend that Memeland owes no liability for reparation as its act, as I've already maintained, were in consonance with the principles of international humanitarian law and the powers given to it under Article 51 and Article. Your Excellencies, I further quote Amoko versus Iran, where under paragraph 253, it is a firmly established principle that reparations cannot be granted for damages that are speculative. And we contend that Mamaland's claim asserting the death of 10,000 individuals, including civilians, lacks substantial backing in absence of such definitive evidence, which renders the claim speculative as to how many of them were terrorists, how many of them were civilians, and how many of them were the direct intentional target of our attacks. We contend that Mamaland was in breach of its international obligations and hence is liable for reparations in turn to Memeland because of the loss of life and property that we incurred due to the acts of freedom warriors directly attributable to the state of Mamaland, for the breach of satellite communication services, for the nationwide widespread violence due to the deep fake of Mr. Yoda created by freedom warriors based on our learnings, and lastly, the breach of personal data over 25 million users from Memeland using Brat app, a breach carried out by freedom warriors itself. Your Excellency, that concludes my submission. I request you move on to prayer. For the aforementioned reasons, the Republic of Memeland, the respondent in this case, respectfully prays the Honorable Court to dismiss the complaint with costs as the applicant has raised non-maintainable claims before this court, to establish state responsibility on the part of Memeland for not taking care of a terrorist outfit flourishing in their territory, to condemn the misuse of the court process by Mamaland, and to allow Memeland to pursue its interests in furtherance of its obligations to safeguard its citizens and territory, and to command Mamaland to deliver requisite reparations to Memeland so that the status quo ante can be restored, and any other relief that this court deems fit. Thank you, Your Excellencies. May it please the court.
Your Excellencies, as the applicant state stands here, tries to provide certain rebuttals to the respondent state, we are extremely sad to report that much of the case that was argued by the respondent state is a factual lie, and the operative parts of their arguments are based upon lies. What are these lies which were made here to mislead the court? Firstly, that the state of Memeland had precise locations and the attacks were precise, and that 10,000 people who died were primarily belonging to a terrorist group, and only a very few of them belong to the vulnerable groups. Your Excellencies, we humbly request this court, before making any allegations, to verify it from the fact sheet. There is nothing in the fact sheet which mentions this. However, on the contrary, paragraph 10 mentions that most number of people who died, a large amount of people, were belonging to the vulnerable group, were the civilians of the country. Secondly, Your Excellency, they say that the only reason they use the weapons of mass destruction is to prevent the terrorists from acquiring it. Your Excellencies, there is nothing in the fact sheet to show that there was even a remote chance of the terrorists even acquiring these weapons of mass destruction. Thirdly, Your Excellencies, they also contest that a lot of people who died were basically terrorists. Your Excellencies, the total population of this country is 10 million. Out of that, 10,000 people have died, which constitutes 0.1% of population. In terms of India, that would be 14 lakh people died. The respondent state wants the court to believe that in absence of any explicit fact, that each of these people killed belong to a terrorist group. Further, Your Excellency, they also submit that they did not block a humanitarian aid. However, Your Excellencies, as the customary rules established for the law of armed conflict by the ICRC, the Red Cross Society, it clearly mentions that all obligations for providing a humanitarian aid and the passage for such humanitarian aid lie upon the belligerent, which in this case is the respondent state. Your Excellencies, after such mislead, we would like to bring this court back to the original facts of the case. And for this, we would refer and we would make a fact wherein we could see the applicant state as let's say being India and respondent state as let's say being USA. What happens is there's an attack in USA by a terrorist organization which is internationally known, let's say Al Qaeda. This organization, because it is internationally known, it is also banned in the country of India. However, there is no trace of this organization operating from the country. Now, there is an attack that happens on the USA, let's say the 9/11 attacks. And in retaliation, without any evidence of attribution, without any sort of attribution to the Indian state, what they end up doing is they set up WMDs, weapons of mass destruction, which by their very definition are weapons which are equal to the class of nuclear or biological weapons. And they say that somehow AI will help them make these weapons targeted. Your Excellencies, there's nothing to show that there were any precise locations, that there was any identification. And then the only claim that they make is very representative of the USA that we only send we only send weapons and our armies here so that we could help you with your terrorist situation, which in the first place did not even exist within the country. Your Excellencies, as we conclude our submission, further with regards to admissibility of the issue cannot be a question before this court because the clarification quote to the Moot proposition restricts the interpretation of issue 1 merely to applications where we can show that there's either another forum or a municipal law jurisdiction question is being asked. Your Excellencies, as we conclude our submissions, we humbly request this court to verify the facts that the respondent states have put forth and ask them as to where do they get these factual backings from for everything ranging from targeted attacks to only terrorist strike to only self defense being exercised to also that the terrorist organization was based out of the country. We humbly request this court to verify these facts. But, Your Excellencies, with that we submit. It was a genuine honor to argue before this court.
At this juncture, the Council would seek to clarify that the proposition specifically states, and the Council quotes, in addition, the use of AI-controlled WMDs caused extensive death and destruction of lives of more than 10,000 people, including the most vulnerable groups, not primarily, Your Excellencies, including. This including can mean there was one death of, there was 5 civilians died, not belittling the lives of anybody, but it can also mean that there were only 5 civilians and the rest were primarily the freedom warriors. But it can never mean that most of those deaths in the 10,000 number as given by the state of Mamaland were civilians. And it is ironical that they would accuse us of misleading the court and yet continue to do the same.